Court handed down their decision on SB1070, the Arizona law that was really designed to make life difficult for undocumented immigrants in the state. And this has been an ongoing part of Arizona's attempt to seek attrition through enforcement. They're trying to make life as difficult as possible so that immigrants would self-deport, for lack of a better term. Now, one of the other provisions that was initially enjoined was revived here at the Supreme Court level, and that's the Show Me Your Papers provision. Now, this is going to allow Arizona officers to determine anyone's status when they come into lawful contact with them. So when they are engaging in a traffic stop, or, for example, they see someone, the court uses the example of jaywalking, they can stop that person in their ordinary course of work, give them a citation, and determine their immigration status. Now, there's an interesting question about whether or not that will be able to be attacked later on, because the court says, at least as we read the statute now, we don't see any constitutional problems. But depending on how it's enforced, there could be problems arising. And so, for example, with that jaywalking hypothetical, if an individual is jaywalking and the police officer were to stop them and try to ascertain their immigration status, they can only do that so long as the stop isn't going to be prolonged unnecessarily or unreasonably. So if, for whatever reasons, they have the person there, they're trying to issue the citation, and they're trying to determine the immigration status, and minutes go by into hours, now that could become unlawful conduct. But since we're at a preliminary stage here, the law hasn't taken effect yet, the court didn't want to read into the law unconstitutional measures. They want to see first how the state applies the law and how it actually carries it out. It is interesting to see that they want to take a wait-and-see approach, but not unexpected, because generally courts don't want to strike down laws as unconstitutional if they don't have to, especially when it's at a preliminary stage and they haven't had any evidence of violations yet. The other three provisions that were struck down were on preemption grounds, so they're just saying the state doesn't have the right to operate in this realm. Whereas here, when you're processing someone that you've stopped, arrested, etc., that's always within the realm of the state officer. So they wanted to give them an opportunity, I think, to show that they were going to carry this out in a lawful manner. And so, for example, if someone's stopped for a DUI, generally they're going to be arrested, booked, and processed through the system. And within that processing portion of it, they're going to have their ID run, and then an immigration detainer, if there is one, will come up and will say this person is here subject to an ICE detention, or even that the person is here unlawfully, and then we'll issue an NTA if ICE wants to come and pick them up. So it's not terribly unusual that the court would want to play it out this way. I don't think it's that unexpected. In a way, it's a compromise, too, so that here we have a situation where you can't say that the federal government is prohibiting a state from enforcing the laws, because Arizona was arguing all we want to do is see that the federal laws are being carried out. And so when we stop somebody, we want to verify that they're in the country lawfully. And if not, we will pass them on to immigration authorities. And in effect, that's what this portion of the law is doing. It's a little broader in some aspects, because you might not normally have a police asking a jaywalker or somebody else whether or not they're in the country lawfully. So here we're going to have a larger number of individuals being processed through the immigration resources to verify their status. But at the end of the day, that's what's happening. The state is simply verifying their presence in the country, and then it's up to the federal government. There are a number of states that have been acting on very similar issues. This whole idea that the federal government's unwilling to enforce the law, so the states need to step into the void. And the opening pages of Justice Kennedy's opinion really are going to present a problem for those states, because the opinion is very clear. One, that immigration is a federal issue. So it's going to be one that's decided by the federal government, Congress, and or the executive, or both working together. And that second, immigration, in a sense, is a police power of the president. That means the president is able to use great discretion in deciding which resources to use, how to use them effectively, who to remove, who to not remove. And having said that, going on and then striking down some of these portions of the law, it's going to be much more difficult for more states to try to enact this type of legislation. The only provision that was upheld is really the show me your papers, the are you here lawfully or not, which is what people were doing generally under the Secure Communities program. Anytime someone was being arrested, they were, if you're a member of Secure Communities, you were running that person's identification, their status, to figure out whether or not they're here lawfully. So if that's the only portion that survives, really that's not much more than the status quo in the vast majority of the states. And all these other attempts to criminalize behavior at the state level that wasn't a federal crime are going to be very difficult to persuade a new court to say, yes, this is in fact a valid exercise of state power rather than federal power. I think some of the most interesting language that comes out of this decision comes from Justice Scalia. And of course he is very much of an originalist, looking back at the founder's intent. And he has some very acerbic, even for him, language in this opinion, talking about whether or not states would ever have decided to join the Union had this decision been a part of the Constitution, this holding. And he very much is swinging over the sides of state rights, state power. Anything not delegated to the federal government remains with the states, and therefore we should have a situation where states have much more power, and he says that the ultimate power of a state is the power to exclude people who are undesirable. Now, back in the 1700s, that in fact was the case, and he makes the claim that it was the state's determination or their need to exclude people that eventually led to a national system, a national framework of immigration. But now that we have this national system, it's tough to see how his argument fits into 2012. He cites many historical documents, the Articles of Confederation, he cites the Federalist Papers, letters from James Madison, all talking about immigration in the 1780s. And now when we're in a framework of a situation where we have 50 states that are much more one union rather than the separate entities that were at that time, it's a different concept, I think. And so when he gets into this argument, this question, I think he puts it very clearly at one point in time that the federal government is refusing to enforce immigration laws, and now they're prohibiting the states from doing the same, which I think is an improper framing of the question. It's not that they're prohibiting the states from enforcing immigration laws, just they're saying you can't criminalize other conduct other than what we've already established under the federal framework. And the fact that the federal government isn't enforcing immigration laws is really throwing a blind eye to the statistics that under the current administration, removals have been at an all-time high. Every year has set a record for the number of removals every year that we've continued from 2008 up until now. So the fact that the federal government isn't enforcing immigration law is really sort of a red herring to muddy the argument, and I think somehow upset the populace a little bit more than is necessary, especially from a Supreme Court opinion.